This is the Constitutional Era, Objective 2, Part 2, about how this new document called the Constitution was actually ratified by the states. Now, if you remember, there were 55 delegates to the Constitutional Convention, and of those 55, 13 had left over the course of the summer. By the time it was time to sign the document, only 42 were left, and actually, 3 of those 42 decided they were also going to leave to fight ratification of the document they had just helped to create. 3 of the delegates didn't even sign it. They just went home to fight the ratification of the Constitution itself. They were so upset with how it turned out. Only 39 of the original 55 signed it, and none were completely pleased with the end result. Now, that's primarily because hardly anybody got exactly what they wanted out of the thing, if anyone. The Constitution, once again, is known as a bundle of compromises, a series of agreements between people when they couldn't totally get exactly what they wanted, so they had to settle for something in between. Well, 9 of the 13 states were needed to ratify or approve the document as the new law of the land, but many Americans didn't trust the motives behind the document. Remember, there were some who really liked the Articles of Confederation. They liked that the states had all the power, and they liked that the federal government had been very limited under the Articles of Confederation. They were willing to agree to a revised version of the Articles of Confederation. This was not that, decidedly not that. This was a complete scrapping of the Articles of Confederation. So some people didn't trust the motives behind the document because it was not a revised version of what they had. It was an entirely new thing. Also, they didn't like the idea that it had been completed entirely in secret. The fact that it was happening in secret really irritated some Americans because they liked what they had and just wanted it revised, not totally changed. And this seemed like a bit of a power play by the wealthy upper class that feared mobocracy and was trying to protect their interests. Okay, but before we go any farther, let's review what we're talking about here. When we say a confederacy, or a federal government, here's what we basically mean. A Confederate government, like we had under the Articles of Confederation, is going to give the most power to the most basic level of government, the local level of government. They're going to say that the national level of government, the federal level, is going to stay out of your business, and you're going to govern yourselves as much as you can locally. County governments are going to have more power than the federal level. And the states are going to have more power than the federal government. The federal level of government may be on the top, but it's going to have almost no power whatsoever. And the laws of nature, the idea of life, liberty, and property, laws that are given to you by your creator, not by governments, are going to rule the day as well. And if any federal government tries to overthrow those, or change those, or take those away, then people are obligated to overthrow that government. So basically a confederacy or a confederation is where states have all the power. A federal government, on the other hand, or the concept of federalism, is when the federal government shares power with the states. The national level of government has a bunch of things that they can do. The state has a bunch of things that they can do, and then there are some powers that they both can do. Now, this new federal model is what was being proposed in the Constitution. The new document gave far more power to the new federal or national level of government than had ever existed before. And yet, you could loosely make the argument that the Articles of Confederation had actually been a federal government. They did have a national Congress, after all, but realistically, it had almost no power whatsoever. I mean, it had to ask the states for permission to do things. So what they were going for here was a stronger federal government. Well, as you can imagine, once this Constitution comes out, there's all sorts of debate and discourse on it. And there were 2 distinct sides. One side was the Federalist side. Now, the Federalists were basically all the people who had been at the Constitutional Convention and had put this document together. They therefore were in favor of the passage of the Constitution. They wanted the Articles of Confederation to be totally abandoned, and they wanted to limit the power of the states, not eliminate it, but just give the federal level of government, the central government in the country, more power than it had. Now, there was some discussion about a Bill of Rights. They didn't feel a Bill of Rights was necessary because each state already had a Bill of Rights that protected the citizens against the powers of government. But here's the biggest key. The majority of the Federalists were wealthy lawyers, bankers, landholders, the educated upper class who believed in stronger central government, again, basically to get rid of the mobocracy. Now, it doesn't mean that every Federalist was wealthy. There were some people who agreed with the Federalists that didn't have a ton of money and were basic common citizens. But the key, again, is that it's an upper class that wants to protect their interests against the mobocracy that had developed. Now, they presented their arguments to the public in a group of essays called the Federalist Papers, which were written by James Madison, Alexander Hamilton, and John Jay, J-A-Y. Some of the most notable Federalists were, again, people who were at the convention: George Washington, Ben Franklin, James Madison, who had written the document, basically, Alexander Hamilton, John Jay, John Marshall, a future Chief Justice of the United States, who would be the Chief Justice for 34 years, and now someone who wasn't at the convention but agreed with them, John Adams. He initially was suspicious of this, did not go to the convention, but now decided he wanted to be a part of it. Now, on the other hand, you had a group of people called the Anti-Federalists as well. And the Anti-Federalists were, of course, against the ratification of the Constitution. They liked the Articles of Confederation and wanted them amended or fixed in some way, but they didn't want them totally scrapped, and that's what had happened at the Constitutional Convention. Remember that the Anti-Federalists were people who believed that state power was better. They wanted more power for the states. They were very afraid of increasing power on the federal level, and they felt that if that was going to happen, they needed to be guaranteed a national Bill of Rights, some protections for the people against the power of this new government that they had. Now, again, the common man was basically the most prominent anti-federalist. Federalists had been made up of the wealthy, but the Anti-Federalists had been mostly rural farmers who believed in the Articles of Confederation and states' rights. In essence, they did not trust the motives of the upper class. Now, they had a series of essays themselves. They were, of course, called the Anti-Federalist Papers. And some of the most notable Anti-Federalists we've talked about already, of course, are Thomas Jefferson, but also guys like Patrick Henry, he of the Give Me Liberty or Give Me Death statement, Samuel Adams, who had been a leader in the Revolution, and Richard Henry Lee, who's often given a lot of credit for actually writing the Declaration of Independence, not Thomas Jefferson, but nonetheless was a big prominent figure at that time as well. The Federalists are eventually going to win this debate and get ratification of the Constitution, though, because of a promise to add a guarantee of individual rights that protects citizens from the new, stronger government. In essence, the first 10 additions to the original document, also known as the first 10 amendments. That's what you're doing when you add something to an original document. And those first 10 amendments to the U.S. Constitution are called the Bill of Rights. The First Amendment guaranteed freedom of speech, religion, the freedom of the press. You know, when they say the public has the right to know, freedom of the press to let the public know when their government is being corrupt, the freedom to assemble and to petition or question your government and bring up causes against your government, the right to bear arms in the Second Amendment. The Third Amendment said that you did not have to house U.S. troops, which had been customary when the British ran the country. You used to have to let a British soldier stay with you, and you had to feed him if he knocked on your door demanding a place to stay. The Fourth Amendment guaranteed protections against illegal searches and seizures, and the Fifth Amendment guaranteed the rights of people who were accused. You can plead the Fifth to not be a witness against yourself, for example. The Sixth Amendment called for protections for people who were on trial, speedy trials, how you select a jury, things like that. Also the idea that you're, innocent until proven guilty. The Seventh Amendment dealt with jury trials where the crime or where the penalty was not criminal and there was not a jail time or any other type of criminal offense, but a civil offense where the punishment is usually based on money. The Eighth Amendment set restrictions on cruel and unusual punishment by the government, while the Ninth Amendment gave the people probably what they wanted more than anything else, that guarantee of rights that are not listed in the Constitution. In other words, John Locke's natural rights in the Ninth Amendment: life, liberty, and property. And finally, for those people who were anti-federalist and wanted power remaining in the states, the new Bill of Rights actually gave them a concession as well. It said that anything not written in the Constitution is up to states to decide for themselves. And that left a pretty wide amount of ground for the states to still have their own unique set of powers. Now, with that eventually came the ratification of the Constitution in 1788. Although if you look at this chart here, it didn't go very well at first. The majority of people in New York, for example, either didn't want it or were no returns whatsoever about it. But the bottom line is people started to come around. In 1787, Delaware, Pennsylvania, and New Jersey, in this general region right here, they became the first to ratify the document. But the big year was 1788, when Georgia, Connecticut, and Massachusetts, which included Maine — Maine was a part of Massachusetts at that time — Maryland, South Carolina, New Hampshire, Virginia, and New York all ratified the document. Now, they had enough at that point. North Carolina jumped on board in 1789, and even Rhode Island, who didn't even want to go to the Constitutional Convention to begin with, decided, well, I might as well jump on board too, and ratify the document in 1790. And ultimately, whether you were Federalist or Anti-Federalist, to a degree you got what you wanted. The Federalists did get a stronger central government that would protect the interests of the wealthy against mobocracy, a government that could step in when it needed to step in state matters. And the Anti-Federalists got their states' rights through the 10th Amendment. If it wasn't written in the Constitution, it was still up to states to decide, and there were plenty of things that were still allowed for them to decide on. They also got their Bill of Rights to protect them against this new, more powerful federal government, with natural rights of life, liberty, and property included in the Ninth Amendment. So ultimately, that was pretty good. The Constitution as we know it today has approximately 4,500 words, which makes it the smallest governing document in the world. No nation in the world has a constitution of fewer words. And frankly, there isn't a state in the United States that has a state constitution of fewer words. New Hampshire has the smallest one at 9,000 words approximately, which is twice as big as the U.S. Constitution. Alabama's is 332,000 words. So, you know, they have very big constitutions in the states, and frankly, they have to change all the time because they're very specific. They have to be. The 10th Amendment has allowed for them to be specific, while the Constitution has been vague. And that's also part of the genius of the Constitution as well. Because it's vague, it's left to people of any time in history to interpret for themselves as they see fit. The founders were smart enough to know that they didn't know everything, and that laws that they would create if they were too specific wouldn't apply in 50 or 100 years, and the document could potentially be scrapped. So they let it be written to be vague and incomplete, so future generations and their court systems can interpret it the way they needed to meet their needs. That in and of itself is fairly brilliant. Now, you are going to get people who will say that the Constitution is too incomplete, that it's too vague, that it's too crude. And they're right to a degree. The Ninth Amendment is used by both the pro-life and the pro-choice side in the abortion debate about whether or not they should be legal or not be legal. The pro-life side has argued the Ninth Amendment right to live, saying that the baby has a right to live, but the pro-choice side has argued property and liberty, saying that the first and foremost property of any woman is her own body, and she has the freedom to do with it what she chooses. But no matter how you look at it, the point is that we really haven't been able to decide on this issue since the early 1970s. And critics would say that makes it incomplete and crude. Well, no matter how you look at it, it's still with us today, and it's still a living, breathing document that changes with the time. 7 articles are there, written in Roman numerals, to outline what the legislative, executive, and judicial branches can do and how they're structured. And there are 27 additions or changes to the original draft. 27 amendments. That's what it means when you add to something or change it. You're amending it, including the first 10, probably the most important ones, the original Bill of Rights of 1791. Okay, that's it. Thanks for listening.